So now let's continue. We are still on the case. We have finished with Madame Pozzard's case where she was supposed to appear on a certain date to perform, to start, and she could not because she fell sick. They had a substitute and they cancelled their contract. And she thought that there was no way they were supposed to have cancelled it. And the court said they were right to cancel it because she breached a condition. The moment you breach a condition, it leads to discharge of the contract. And I said, in her case, they could not sue her for damages. Why? Because of the fact that she felt sick. So that is it. Now let's go to another case that relates to warranty. And that is Bethany versus Guy. Where is that one? Bethany versus Guy. Now, you know this is a name. Some will pronounce it Guy. Remember, it's G-Y-E. Others pronounce it Gay. But please, I prefer Guy to, it is a noun. So whatever it is. Bethany versus Guy. Bethany versus Guy in 1876. The same issue, opera singer. So the plaintiff, I hope you know who the plaintiff is. We have learned it. Did you say it's Guy? If you said that, you know you were wrong. Remember, the plaintiff is always the first person. So, Bethany. So this plaintiff was an opera singer. The defendant was a director. Director of what? Royal Italian Opera in London. Royal Italian Opera in London. That is where the defendant Spires. No, the defendant Guy was the director. Now, what was the agreement? The agreement was that Bethany was going to sing in Great Britain, in theaters and halls. So they agreed that she was going to sing in Great Britain, in theaters and halls for a period commencing, that means it will start on 30th March 1876. No, 75, 1875. And to be in London for rehearsal. I have underlined rehearsal. So you see, one of the terms was that she was supposed to be in London for rehearsal. So that was called the rehearsal clause. The rehearsal clause is one of the terms. Then we have the performance clause. The performance clause, the performance will start on 30th March 1875. But they said that she should be in London for rehearsal 6 days before the engagement began. So they said, we have entered into a contract with you, you are going to perform. But you see, you should come to London 6 days for rehearsal 6 days before the commencement of the program. But the plaintiff, Bethany, felt sick. You see, the commonality. She felt sick. She felt sick. This one too, she felt sick. So the plaintiff felt sick and therefore arrived on 28th March. 28th March. Remember, if she arrived on 28th March and the program is supposed to start on 30th, that means the rehearsal will be how many days? 2 days. But they said how many days? 6 days. So it means she has breached the rehearsal clause. So what? The program itself has not started. The program is going to start on 30th. She arrived on 28th. But they said she should be in London 6 days before the commencement. So 6 minus 30 would have been 24. 30 minus 6 would have been 24. That means she was supposed to have been there on 24. But she could not go on 24. She went on 28. That means she has breached the rehearsal clause. The question now is, so when she came, they said they have cancelled the contract. They have cancelled the contract because she has breached the rehearsal clause. And that's why she sued them, that you cannot cancel the contract. They have cancelled and they have given it to someone else. They said, no, you cannot cancel the contract. So now it goes to court. The question is, the breach of the rehearsal clause, is it so important that it will affect the root of the contract, the performance? Or it is less important? You and I know that they already knew her skills. They knew what she could do before they engaged her. So does he necessarily have to go to London to rehearse for 6 days before she could perform? Certainly every reasonable person will say no. Even though it was part of the agreement. She had breached it all right, but it's not so important. She's there on the 28th. The program will start. So she still has 2 days to rehearse. And certainly, she can still perform. So the court said they were not right to cancel their contract. So in that case, if they did not allow her to perform, what happened? She can now sue them for damages. We shall learn about what damages are. She sues them for damages. For breaching their contract. Because if they cancel it, that means they have breached their contract. So that is for that one. So I said hell. Rehearsal clause was subsidiary to the main purpose of the contract. And the main purpose is to do what? Sing. So the main purpose of the contract. And therefore, its breach constitutes breach of warranty only. It's not a breach of condition. So it cannot lead to the start of the contract. So they will have to compensate her. They will have to compensate her. But they can also have counter compensation. They can also have counter compensation. What is counter compensation? If they also think that because she did not come on that day, on the 4th, no, the day she was supposed to come, on the 24th, they might have rented a hotel for her, and that for the number of days they had paid, and then they have wasted about 6 days if they were taking a certain amount times 4. So that money they paid, they might have prepared maybe food and whatever. So if they think that they have also lost something as a result of her refusal to report on the 24th, then whilst she is seeing them for compensation, they can also have counter compensation. So they can also sue her and also claim damages from her. So that is for that one. Ladies and gentlemen, let me sum up what we have done so far. We are on breach. We have talked about the fact that when you breach a condition, now I have explained to you what is meant by that one. Then when you breach a condition, I've already told you the remedies. Even though I didn't say, I've said it. When you breach a condition, number one, if somebody breaches a condition, you can sue the person for damages. I've already told you that. Then you also have the right to cancel it. I've already told you that. But if it's a warranty, you can sue for damages, but you cannot cancel it. These are the remedies. Remedies means what can you do when the person breaches a condition. You can sue for damages, you can cancel it. If it is a warranty, you can sue for damages, you cannot cancel it. So that is for that one. Then I've used cases to support that. Now let's go to the last aspect. Remedies available to an injured party when there is breach of contract. Remedies. What can you do? Somebody has breached a contract. Breach of contract. Breach of contract. the person fails to perform his or her obligation, what can you do? There are the remedies available for you. And you are called an injured party. You are called an injured party. You are called an innocent party. Innocent party. So when somebody breaches a contract, what can the injured party do? What can the innocent party do? You can also be referred to as the party aggrieved. They can also refer to you as the party aggrieved. So you see, I've used 3 words to describe the person. The person is called an injured party. The person is called an innocent party. The party is said to be the party aggrieved. The party aggrieved. So, in the event of breach of contract, what are the remedies available to the injured party? What are the remedies available to the party aggrieved? What are the remedies available to the innocent party? Very simple, straightforward remedies. Number 1, you can refuse to perform your obligation under the contract. So when somebody breaches the contract, you can treat the contract as discharge and also refuse to perform under it. When the person breaches the contract, you can treat the contract as discharge and refuse to perform under it. So he failed to supply the raw materials. So you can treat the contract as discharge and you also fail to pay your money. So refusal to perform. When a condition is breached, you can consider it as this, you cancel it. And then you refuse further performance. So that is number 1. Number 2, you can sue the person on quantum merit. On quantum merit. You know, law is full of Latin. So if you want to learn law, then you learn a lot of Latin phrases, Latin words. Quantum merit, what does that mean? Quantum merit means how much does it worth? How much does it worth? How much does it worth? Now, when do you see somebody for quantum merit? If you have entered into a contract with somebody and you have performed part of the contract, you have performed greater part of the contract, but the person is refusing to pay you for the work you have actually done, then you go to court and you want the person to pay you for the work you have actually done. Then when you go to court, you say you are suing the person on quantum merit. That means you want the court to compel the person to pay you for the work you have actually done. Let me give you an example. You entered into a contract with somebody to weed the person's farm, let's say 2-acre farm, and you charge the person 1,000 Ghana cedis. You have done half of the work, which is 1 acre, but you cannot continue because of one reason or the other. And the person says, I will not pay you anything till you finish everything. If you think that you cannot further perform, but you want the person to pay you for the work you have actually done, the work you have done, how much does it worth? So you see the person on quantum merit, and the court will order them. If the court sees that, yes, you deserve it, then they will order the person to pay you half of the money for the work you have done. So that is what is meant by suing on quantum merit. Now, there is a case to support that, and that is Craven Ellis versus Canon Limited in 1936. What happened was that the plaintiff was employed by some directors of a company under a deed. The employment was under a deed. Now you know what is a deed. If a contract is made by deed, you understand it. Which provided for remuneration, so they were going to pay him. But there was a certain condition that the director, he was as a director. And they said he must have what we call director's qualification shares. Within 2 months of his appointment, they said, when we give you appointment, please see to that you have a certain kind of shares we call director's qualification shares within 2 months. If you don't have it, it means the contract will be invalid. Unfortunately for him, he together with other directors who engaged him could not have the director's qualification shares. That then means that the contract became invalid. So he was no more a director. He ceases to be a director because he didn't fulfill that condition. He couldn't have the director's qualification shares. And what did they say? They said, okay, we will not pay you. The 2 months that you have worked, we will not pay you. And he said, please, pay me for the work I have done for the 2 months. They said, we will not pay. That's why he sued them. And he succeeded on quantum merit. So they were made to pay him for the work he has actually done. So that's it for that one. The next one is that you can sue for damages. What are damages? Damages are financial compensation that are awarded to an injured party when there is breach of contract. The key word here is financial compensation. And when do you sue for that one? Okay, let me give you an example and you understand it. You have entered into a contract with somebody to supply you with raw materials. By the time you engage the person or you entered into that contract, one was, let's say, 10 Ghana cedis. So you said the person should supply 10,000. So you pay 10,000. This person breached the contract by not supplying. Then the person said, okay, take your money, take your 1,000 Ghana cedis. After keeping the money for, let's say, 6 months, now if you want to go and buy the material, one is probably going to cost you 15 cedis. It was 10 cedis, but now it's going to be 15 cedis. That means if you take the 10 cedis per one, which is your 10,000 Ghana cedis, you are going to lose 5 Ghana cedis per one, which is going to be 5,000 Ghana cedis. So if you think that the person's breach will let you lose that amount, then you will see him for that loss. So if you say you are suing the person for damages, it means you are asking the court to let the person pay you the money you would have lost if you had taken them 10,000 Ghana cedis. Here it would have been 5,000, and that is what you call damages. So it is a financial compensation that the court awards to an injured party when there is breach of contract. And if you think that you have lost something as a result of the person's breach, that's when you sue the person for damages. There are 2 types of damages. Either it is liquidated damage or unliquidated. Liquidated damage means that, for example, A enters into contract with B for supply of raw materials. A and B, they both agree that A, if you supply the raw material, B, if you supply the raw material to me and I don't pay, then this money that I'm supposed to pay 10,000 Ghana cedis, I will pay damage of 5,000 Ghana cedis. Then B2 will say that if I don't supply, I will pay you this. It means that they have agreed on the damages. So where the parties themselves have agreed on the damages to be paid, then it is called liquidated damage. So when there is breach, then the other party will have to pay that damage they have both agreed. But if he says, I will not pay, you go to court and sue the person, then the court will compel the person to pay that damage both of you agreed, which is the liquidated, which will be the 5,000. The other side is unliquidated. That means there was no agreement to the effect of the damages that is supposed to be paid. So when it occurs, like the case here, 10 cedis, now it's 15 cedis. It goes to court, you see the person for, you say that you are suing the person for damages. Then it will be determined how much, is the court that will determine how much is supposed to be paid to you in terms of damage. But the liquidated one, you determine it. But the unliquidated is the court that determines the damage that is supposed to be paid. So that is for the damages. That is for damages. Where is that one? So you can see for damages. The next one is that you can go to court to seek for injunction. Have you been hearing this word? They said, okay, let's see whether this one, if this one stops abruptly, then there will be a third video. So let's take note of that. Now, injunction. At times you hear that they say that a particular football team has placed injunction on the match. Have you heard of that before? That means that they are saying that the court should order that the match should be called off. So injunction is an order that comes from court. It's court order. So that's the first thing you have to note about injunction. It's an order from court. When the court, if you go to court and the court places that injunction, it means the court is going to restrain the person from performing an act. You'll be restrained from performing an act. You'll be prohibited from performing an act. And that is why we have what we call prohibitory injunction. For example, you bought a piece of land from somebody and the person already told you that, please, this land is for farming. Don't build any structure on it. If the person saw that you were building a structure on it, the person will go to court and ask the court to place an injunction on it. If the court accepts and they place injunction, they will say stop work, don't build the structure on that one. That means they have placed an injunction. That means the court has given you an order to restrain you, to prohibit you from building on that particular land. And it is called prohibitory injunction. But there is another type of injunction that is not an order to stop, but that will be an order to do something. That will undo your act. You have done something, you have breached a contract. The court will ask you to do something to undo that breach. For example, there is a piece of land there. You have gone to place a landmark. Where you place the landmark, you have extended to somebody's land. The person will go to court. If the court will ask you, remove that pillar from where you have placed it. That is not your land. And go and place it somewhere. You see, you have done something. And the court is giving you an order to remove the pillar. So you are performing an act that is going to undo your act. So that is what we call mandatory injunction. So either an injunction is prohibitory or it is mandatory. So that is that one. The last one is you can sue for specific performance. You can sue for specific performance. What does that mean? That is very simple. A enters into a contract with B to do what? B is supposed to supply raw materials. What is A supposed to do? A is supposed to pay the money. A has paid the money, but B is refusing to supply the raw materials. Then B is saying that please take your money. It is not because there is frustration, but he is unwilling to supply the raw materials. But A wants him to supply the raw materials. But he said, take your money. Okay, even the money, you gave me 10,000. I'm adding 5,000 to the money. Take your money. Then the person says, I don't want the money. I want you to perform your obligation. What is that obligation? By supplying the raw materials. If that is the case, then you have to sue the person for specific performance. So that is what is meant by specific. Look at it, performance. You are performing your obligation. That specific thing you said you were going to do to supply the raw materials, to weed the person's farm. You have taken money from somebody to clear his land, his farm. Then you don't want to clear it. You say, please take your money. I'm even adding money. The person say, no, I don't want it. Go and weed the farm. You say, you know weed. The person will see you for specific performance. In order to let the court to compel you to perform the duty that you have undertaken to perform. Ladies and gentlemen, that brings us to the end of law of contract. Now, let's look at our person here, whether we have been able to achieve our objective. Time is not on our side, so I'm going to run. What is discharge of contract? 3 marks. State and explain any 4 ways by which a contract may be discharged. 12 marks. Give any 4 remedies available to an injured party when there is breach of contract. Distinguish between conditions and warranties. That brings us to the end of the lesson. So from today, we will not meet again. We will meet on 25th September when school opens. Please remember I have told you, you will write exams on all the 7 topics we have done during vacation. Remember, we have done controlling communication, we have done decision making, office personnel, the various departments and their functions. We have done law of contract, and then at the others we have done 7. You have exams, and I'm giving the date for the exam. 3 weeks. My school. This is not a test. It is an exam. So you have to study your materials. Don't forget, when you come to, there will be hot tea. You and I are the only ones who understand what is meant by hot tea. Study effectively so that you are not found wanting. Remember to report on the day school reopens. I have told you that if you come late, depending on the number of days you reported late, the school is going to punish you to that effect. So if you are 1 week late, you'll be punished for 1 week. 2 weeks, 2 weeks. A day, and so on and so forth. So don't try to be late. Till we meet again another time.